a stranger transferred $110 million to my account. I had never seen that kind of money and thought it was a mistake. I called the bank to return the money, but the manager said, "Ma'am, this money has belonged to you for a long time. The sender asked us to pass on." Good day, dear listeners. It's Maria again. I'm glad you're here with me. Please subscribe to my channel and like this video. And also, let me know in the comments which city you're listening from. That way, I can see how far my story has traveled. I used to think that a quiet life was the same thing as a safe one. For 3 years after the divorce, I had built something small but solid for myself and my son. A 2-bedroom apartment on the east side of Columbus, Ohio. A steady job at Hartwell & Associates, a mid-sized accounting firm where I had worked for 9 years, long enough to know every client's tax anxiety by name. A routine. Alarm at 6:15, Ethan's lunch packed by 6:50, drop him at Riverside Middle School by 7:30, desk by 8. Coffee, spreadsheets, quiet. My name is Sarah Mitchell. I was 38 years old and I had learned, slowly and painfully, that peace was something you had to construct deliberately, brick by brick, after someone spent years dismantling it. That someone was Derek. Derek Mitchell, my ex-husband, married now to a woman named Vanessa, who wore her hair in a sharp blonde bob and spoke in the careful, deliberate tone of someone who had rehearsed everything twice before saying it. They lived 20 minutes away in a newer development in Dublin, the kind of neighborhood where the lawns are always exactly the right shade of green. Derek had moved up in the world since our divorce. New house, new wife, new everything. What he hadn't changed was his relationship with our son, which remained precisely as inconsistent and self-serving as it had always been. I didn't hate Derek. Hate is too much energy. I had settled into something colder, a low, steady wariness, the way you feel around a dog that has bitten you once. Respectful distance, minimal contact, everything through our attorneys when possible. And yet, in the weeks before everything changed, I noticed that Derek had been unusually attentive. He called twice in 1 week, not about Ethan's schedule or a school event, but just to talk. His voice was warm in a way I hadn't heard since the early years of our marriage, the years before I understood what that warmth cost. He mentioned, almost casually, that he'd been thinking about us lately, about how well we had managed things. He asked if I'd received any mail recently, anything unusual. I told him no, and changed the subject. I should have paid more attention to the question. There had been other small things. A piece of mail I had nearly thrown away, a cream-colored envelope from a law office in Charleston, South Carolina, with the name Hale and Wentworth, estate attorneys printed in the upper left corner. I had set it on my kitchen counter and forgotten about it for 4 days before finally opening it. The letter inside was brief and formal, informing me that my great-uncle, Robert James Hale, had passed away 6 weeks prior, and that his estate was in the process of being settled. They asked me to contact them at my earliest convenience regarding a matter that concerned me directly. I didn't call immediately. I wasn't even sure who Robert Hale was, not precisely. My mother had mentioned him once or twice over the years. Her father's younger brother, a man who had spent most of his adult life working in private equity and real estate development along the East Coast. A bachelor, reclusive, someone who had drifted away from the family long before I was born. I assumed the estate letter was about some minor formality, perhaps a small personal item, a piece of furniture, something symbolic. I put the letter in a drawer and told myself I'd call on Thursday. I called on a Tuesday, but not because of the letter. I called because of my bank account. It was an ordinary morning. Ethan had a dentist appointment after school, and I was going over my monthly budget during my lunch break, The way I did every month with the same careful, slightly anxious attention I gave all things financial. I opened my banking app. I scrolled to my checking account balance, the account where my direct deposit landed every 2 weeks, the account that hovered, reliably, between $1,100 and $3,000 depending on the time of the month. The number I saw made me set down my fork. $110 million, $110 million. I sat very still for a moment. The break room around me continued its ordinary life. The microwave hummed, Karen from payroll laughed at something on her phone, and I sat there with my salad getting warm and my heart doing something strange and rapid in my chest. My first thought was, this is a mistake. My second thought was, someone is going to come and take this away, and somehow I'm going to be blamed for it. I called the bank. The phone rang 3 times. A manager came on the line, a man named Mr. Caldwell with a measured professional voice. I told him my name. I told him my account number. I told him that there appeared to be an error of approximately $110 million in my checking account and that I wanted to report it. There was a brief pause on the other end. "Ms. Mitchell," he said, "there is no error. These funds were transferred to your account as part of a directed estate disbursement. The sender's instructions were very specific." Another pause. "Ma'am, these funds have belonged to you for some time. The sending party asked that we convey their regards and that you contact the office of Hale and Wentworth in Charleston as soon as possible." I hung up the phone and stared at the wall of the break room. Outside the window, Columbus went about its Tuesday in complete indifference to the fact that my entire life had just shifted beneath me like loose ground. I didn't tell anyone. That was my first decision, and looking back, it may have been the most important one I made in those first 48 hours. I sat in the break room for 7 more minutes after I hung up with Mr. Caldwell, eating nothing, looking at nothing, and then I picked up my fork, finished my salad, rinsed the container in the sink, and walked back to my desk as though the ground were still solid beneath me. It wasn't. That night, after Ethan was asleep, I called the law office in Charleston. The phone rang 4 times before an after-hours recording picked up. I left a brief message, my name, my number, the reference number from the letter and then I sat at my kitchen table with a glass of water and tried to think. I am, by profession and by temperament, someone who works with numbers. I understand balance sheets. I understand that every figure on a ledger has a source, a destination, and a consequence. So I applied that same thinking to what had just happened to me, and what I came up with was not reassuring. Who was Robert Hale, really? I knew almost nothing about him. My mother, who passed away from cancer 4 years before the divorce, had spoken of him only in passing. Her father's estranged younger brother, a man who had built a fortune in real estate and private equity, and who had chosen, for reasons no one in our family ever fully understood, to sever contact with everyone he was related to sometime in the early 1980s. There had been no Christmas cards, no phone calls, no appearances at funerals or weddings. He was, in the family mythology, simply gone, a cautionary tale about ambition and isolation, referenced occasionally and never elaborated upon. And yet this man, this stranger, had left me $110 million. Why me? Of all the people he could have chosen, and surely there were others, people closer to him, business associates, charities. Why had he reached across 30 years of silence and chosen his grandniece, a bookkeeper in Ohio with $1,100 in her checking account, and a 12-year-old son who needed new school shoes? I didn't have the answer yet. But I understood, sitting at that kitchen table, that the answer mattered enormously. Because money of this size did not arrive quietly. It did not stay private. It attracted attention, legal attention, financial attention, and the most dangerous kind, personal attention. And Derek had already been asking questions. I went back to that phone call in my mind, his careful, rehearsed warmth. "Have you received anything unusual in the mail lately?" The question hadn't seemed significant at the time. Now it sat in my chest like a splinter. Small, specific, and wrong. How had he known? That was the question I couldn't answer yet, and it frightened me more than the money itself. Because Derek knowing about a legal matter related to my family, a matter that hadn't been announced publicly, a matter involving a man I barely knew, that wasn't coincidence. That was information. And information, in my experience, always had a source. I made a list. Not on my phone, on paper, in a notebook I kept in my desk drawer, the kind of small spiral-bound pad I used for grocery lists and Ethan's school reminders. I wrote down everything I knew, everything I suspected, and everything I needed to find out. What I knew, $110 million had been transferred to my account from the estate of Robert James Hale. The transfer was, according to my bank, legitimate. I had a letter from the estate attorneys. Derek had asked about my mail before I'd told anyone. What I suspected, Derek knew about the inheritance before I did. I didn't know how or how much he knew. But the timing of his sudden warmth, the specific nature of his question, the fact that he had been calling me at all, it pointed in one direction. What I needed to find out. Everything. The full terms of the will. Whether anyone else had been named, who at the law office had access to that information, and whether Derek had been in contact with them. I also needed, urgently and immediately, a lawyer. Not the kind who handled uncontested divorces and child custody arrangements, a different kind entirely. I wrote the name Marcus Webb at the bottom of my list and underlined it twice. Marcus Webb was an attorney I had met 3 years earlier through a client at my firm, an estate litigation specialist with an office in downtown Columbus, and a reputation for being methodical, discreet, and, when the situation required it, formidably aggressive. I had spoken to him only once, briefly, at a firm dinner, but I had remembered him the way you remember certain people. Not because they made an impression, but because something in your gut files them away for later. This, I thought, was later. I closed the notebook. I checked on Ethan. He was sleeping on his side, one arm thrown over his pillow, his face smooth and untroubled, and I stood in his doorway for a long moment. He didn't know about any of this, and until I understood what I was dealing with, I intended to keep it that way. Whatever was coming, I was not going to walk into it unprepared. I had spent 8 years in that marriage reacting to Derek's moods, his decisions, his version of events. I had spent 3 years after it learning what it felt like to act instead, to choose. I was going to choose very carefully now. Tomorrow morning, I would call Marcus Webb. I would call the estate attorneys in Charleston, and I would begin, quietly and methodically, to understand exactly what I had inherited and exactly what it was going to cost me. Marcus Webb had an office on the 14th floor of a building on High Street with a view of the Scioto River and a waiting room that smelled like expensive coffee and old money. I sat in it the following Thursday afternoon with my notebook in my lap and the letter from Hale and Wentworth folded neatly in my purse, and I waited. I had told my supervisor at Hartwell and Associates that I had a medical appointment. It wasn't entirely a lie. Anxiety is, after all, a medical condition, and I had been experiencing it in considerable quantities. Marcus Webb turned out to be exactly as I remembered. A compact, precise man in his mid-50s with reading glasses pushed up on his forehead and the manner of someone who had heard every variety of human catastrophe and found all of them professionally interesting. He listened to everything I told him without interrupting. He asked 3 questions when I was done. Then he picked up his pen. "Before we proceed," he said, "I need you to understand something. An inheritance of this size, transferred to an individual in your circumstances, will not remain private for long. Attorneys have confidentiality obligations, banks have reporting requirements, and people talk. Whatever you decide to do, and you have every right to accept this inheritance without condition, you need to do it quickly and strategically." I told him I understood. I also told him about Derek's phone call and the question about my mail. Marcus set his pen down. "How long ago was this call?" "The day after the bank transfer posted," I said, "which was also the same week the estate attorneys sent the letter." He looked at me steadily. "And you had not told anyone about the transfer at that point?" "No one." He picked the pen back up. "Then we have a problem," he said. "And it's not the inheritance." He agreed to represent me. We spent the next hour going through the basics. He would contact Hale and Wentworth directly to obtain the full documentation of the will, including the specific terms of the bequest, any conditions attached, and the complete list of named parties. He would also request an audit of the estate's communication records, which was unusual but, he explained, potentially relevant if we suspected that private information had been disclosed improperly. I drove home with my hand steady on the wheel and my mind running calculations. It was during the second week of our process, 10 days after my first meeting with Marcus, that Derek called again, 3 times in 2 days, all of which I let go to voicemail. His messages were casual on the surface but carried an undercurrent I recognized, the careful lightness of a man trying to gauge what you know by watching what you say. On the 3rd call, he left a message suggesting we meet for coffee. "Just to catch up," he said. "I feel like we've been distant lately." We had been precisely as distant as we'd been for 3 years. That was not an accident. That was a boundary. I didn't call back. What I did do that same evening was open the email Marcus had forwarded me. The full documentation from Hale and Wentworth, received that afternoon. I read it at my kitchen table while Ethan did his homework across from me, and I made sure my face showed nothing. Robert Hale had been, by all accounts, an extraordinary man in the specific way of people who are extraordinary only in private. He had built a real estate and private equity portfolio worth roughly $340 million over 40 years. He had never married. He had no children. He had been diagnosed with early-onset Parkinson's disease 6 years before his death, which had prompted him to put his affairs in meticulous order. He had spent the last 2 years of his life in a small house in Charleston with a housekeeper, a nurse, and his personal attorney, a man named Gerald Wentworth. To various charitable organizations, he left a combined total of $120 million. To me, his grandniece, the daughter of his niece Patricia, whom he had last seen when I was 4 years old at a family gathering in Virginia, he left $110 million in liquid assets, with one condition, that I be located and informed personally before anyone else was told. Before anyone else was told. I read that line 3 times. Then I read the final attachment Marcus had included, a supplementary note from Gerald Wentworth, the estate attorney, which had arrived separately and had not been part of the original mailing. In it, Wentworth described, carefully and with evident discomfort, a meeting that had taken place in his office 6 weeks before Robert Hale's death. a meeting he had initially agreed to under the assumption that the visitor was a family representative acting in good faith. The visitor had introduced himself as Derek Mitchell, had described himself as my husband and financial representative, and had inquired extensively about the structure of Robert Hale's estate and the identity of the named beneficiaries. Wentworth had not disclosed anything, but Derek had asked enough specific questions to make it clear that he already knew far more than he should have. Wentworth did not know how Derek had obtained that information. He did know that a junior paralegal in his office had left the firm under difficult circumstances the previous year, a young man who had, on at least 2 occasions, accessed client files he had no authorization to review. I put the email down. I looked at Ethan, his pencil moving across his math worksheet, the small crease between his eyebrows that appeared when he was concentrating. There it was. Derek hadn't found out by accident. He had found out because he had been looking. He had gone to Charleston. He had sat in the estate attorney's office and asked questions. He had, in all probability, paid someone to get him information about my inheritance before I even knew I had one, and now he was calling to meet for coffee. I closed the email. I texted Marcus 2 words. I found it. He replied within 3 minutes. Come in tomorrow. The plan Marcus and I constructed over the following 2 weeks was not dramatic. It was, in keeping with both our temperaments, methodical. The first step was legal protection of the assets. Marcus worked with a financial attorney named David Chu to establish a trust structure that would receive the inherited funds, separating them cleanly from any marital or co-parental claim. Under Ohio law, an inheritance received by one party in a divorce is generally considered separate property, not subject to division. But Derek's lawyers, should he choose to pursue any legal avenue, would likely argue creative alternatives, unjust enrichment, undisclosed assets affecting the original divorce settlement, claims related to Ethan's financial support. We needed the money inside a structure that was airtight before any claim could be filed. The second step was documentation. Working with Gerald Wentworth in Charleston, who had by this point become a cooperative and somewhat remorseful ally, Marcus obtained the full record of Derek's visit to the estate office, the sign-in log, the notes Wentworth had made immediately after the meeting, and a statement from the former paralegal, a 24-year-old named Connor Briggs, who had been located in Nashville, Tennessee, and who, when presented with the legal implications of his actions, agreed to provide a detailed written account of the payments he had received in exchange for information. Payments made from a joint account belonging to Derek and Vanessa Mitchell. That was the documentation that changed everything from a suspicion into a fact. On a Thursday morning, I was sitting in Marcus's conference room reviewing the final file when my phone lit up. Derek, calling for the 4th time in 2 days. This time I answered. Sarah. His voice was careful, warm, precisely calibrated. I've been trying to reach you. I know, I said. I've been busy. A brief pause. Listen, I think we should talk. In person. I feel like there's some distance between us lately, and with Ethan getting older. Derek, I said, I know you went to Charleston. The silence that followed lasted exactly 4 seconds. I counted. I don't know what you're talking about, he said. You visited the offices of Hale and Wentworth estate attorneys. You spoke with Gerald Wentworth. You paid Connor Briggs, a former paralegal, for access to confidential client information about my uncle's estate. I have documentation of all 3 of those things. Another silence. When he spoke again, the warmth was entirely gone. What replaced it was something I recognized, The particular flatness that Derek's voice took on when he stopped performing and started calculating. "You should be very careful," he said. "I am being careful," I said. "That's why I'm telling you now, rather than when you're standing in a courtroom." He hung up. 20 minutes later, my phone rang from a number I didn't recognize. A woman's voice, controlled, furious in the specific way of people accustomed to getting what they want. Vanessa. "Sarah, whatever you think you know." "I don't think," I said. "I have documentation." Those funds were obtained from an estate that Robert Hale was not mentally competent to administer in his final years. We have medical records. We have testimony. If you proceed with accepting this inheritance, we will contest the will on grounds of diminished capacity and undue influence, and we will make it very, very public. I let her finish. "Vanessa," I said, "Robert Hale was assessed by 2 independent neurologists in the 18 months before his death, both of whom certified his full legal competency. Those assessments are part of the estate documentation. So is the timeline of his estate planning, which began 6 years ago, long before any cognitive decline. If you file a will contest, you will lose. And then you'll also be dealing with a separate action for fraudulent interference with an inheritance, which carries civil damages." I paused. "Gerald Wentworth has already provided his full cooperation." The line went quiet. "We're not done," Vanessa said finally. "I know," I said, "but I am, for today." I hung up, sat in the silence of my kitchen, and felt something I hadn't expected. Not triumph, not relief, but a deep, bone-level exhaustion. The kind that comes not from physical work, but from the sustained effort of maintaining composure while the ground shakes beneath you. I called my sister-in-law Carol, my brother's wife, the closest thing I had to a confidant in those days, and told her I needed to come stay with her for a few days. I didn't tell her everything. I told her I was tired and that I needed somewhere quiet to be someone other than the person managing a crisis. She said, "Come now if you want." I dropped Ethan at Derek's on Friday, so the scheduled custody weekend, unchanged and unchanged seeming. Kissed him goodbye and drove 2 hours to Carol's house in Dayton, where I spent 3 days sleeping, eating casserole, and watching old movies. I did not check my email. I did not answer calls from numbers I didn't recognize. I allowed myself, for the first time in weeks, to be just a person in a house, not a plaintiff, not a beneficiary, not a target. By Sunday evening, I was ready. The offer arrived on a Monday. I was back in Columbus, back at my desk at Hartwell & Associates, working through a quarterly audit for one of our mid-size retail clients. My phone buzzed, a text from a number I didn't recognize, which in itself told me something. Derek and Vanessa had moved to an intermediary. The text read, "Ms. Mitchell, we represent Derek Mitchell. Our client wishes to propose an out-of-court resolution that would be substantially beneficial to all parties. Please contact us at your earliest convenience. A phone number, a name. Philip Garrett, Garrett & Simmons, LLC." I forwarded the text to Marcus and typed 3 words. "They're pivoting." "Interesting." He replied, "Don't respond. Come in at 4. I set my phone face down on my desk and returned to the audit. What I felt in that moment was something I want to describe carefully, because it matters. It was not excitement. It was not fear. It was the particular stillness that settles in you when you have spent enough time in the storm to understand its patterns. When you can see the shape of what's coming and it no longer surprises you. I recognized the move immediately. They couldn't fight the documentation. Connor Briggs had signed a statement. Gerald Wentworth was cooperating. The will was airtight. They were out of legal leverage and they knew it. So they were going to try something else. They were going to offer me money to go away quietly. I thought about how much they might offer. 10 million? 20? Enough that most people in my position, a woman living in a 2-bedroom apartment on a bookkeeper's salary, would find it difficult to say no. That was the calculation they were making, that I would be dazzled, that the fear of protracted litigation, the exhaustion of fighting wealthy and determined adversaries, the appeal of a clean resolution, would all combine to make me take whatever they put on the table and consider myself lucky. They didn't understand that I had already done the math. At 4 o'clock, I sat across from Marcus in his conference room. He had a copy of Philip Garrett's firm profile on the table in front of him. Garrett and Simmons, he said. Solid civil firm. They handle property disputes, business litigation, good reputation. Derek's hiring real representation now, which means he's scared. What do they want? I asked. I don't know yet, but based on the text, they want to settle, which means they know they can't win. What are our options? You can refuse to engage at all. You can listen to the offer and decline, or you can counter. He looked at me. What do you want, Sarah? I thought about that question. Not about the money. The money was already, in a legal sense, mine, and becoming more formally mine by the week as the trust structure was finalized. I thought about what I actually wanted as a person from the resolution of this situation. I want Derek to face a consequence, I said, not just to lose, to face something real. Marcus nodded slowly. Then we don't settle. We file. But before we could file, something else happened. Something I hadn't anticipated and which moved me more than I expected. It came in the form of a phone call from my childhood friend, Diane Okafor. Diane and I had grown up 2 streets apart in Cincinnati, had gone to the same high school, and had remained the kind of friends who called each other twice a year and picked up exactly where they left off. She was a family therapist now, living in Atlanta with her husband and 2 daughters. I had, in a moment of exhaustion the week before, told Diane the full story. She called me that Monday evening while I was making pasta for Ethan. I've been thinking about you all week, she said. I want you to know something. What you're doing, protecting what's yours, going through proper legal channels, refusing to be intimidated. That is not normal. Most people don't do that. Most people either freeze or they fold. The fact that you're doing neither says something real about who you are. I stirred the pasta. I'm terrified most of the time, I said. I know, she said. That's what makes it matter. We talked for an hour. She didn't offer advice. She didn't solve anything. She just listened and asked good questions, and at the end said, "You have more people in your corner than you think. Let them in." I thought about that for a long time after we hung up. I had been managing this largely alone, with Marcus's professional guidance, Carol's quiet hospitality, and a great deal of internal self-talk in the small hours of the night. I had been afraid that telling people would make it real in a way that was harder to contain, that the story would get out, that Derek would find out what I knew before I was ready for him to know. But Diane's call had cracked something open in a useful way. She was right. I was not as alone as I had been conducting myself. The following Saturday, I invited Carol to lunch and told her everything. She listened with the focused, practical attention of a woman who had raised 3 children and managed a household budget through 2 recessions. And when I was done, she said, "What do you need from me?" "Nothing yet," I said. "But I needed you to know." She reached across the table and squeezed my hand. "Then I know," she said. "It sounds small." It wasn't. They came on a Saturday. I hadn't expected them to come in person. That was, I realized afterward, a mistake in my threat model. I had been thinking about lawyers and phone calls and legal filings, and I had underestimated Derek's capacity for the kind of pressure that bypasses formal channels entirely. It was 11 in the morning. Ethan was at a friend's house. I was in my kitchen with coffee and my laptop reviewing the draft complaint Marcus had sent over for my comments when I heard the knock at my door. I looked through the peephole. Derek. And behind him, half a step back, Vanessa in a camel-colored coat, holding a paper shopping bag. My first impulse was to not answer. My second impulse overrode it. Know what they're doing. Watch them do it. I opened the door. Derek's face arranged itself immediately into the expression I privately called his listening face. Open, slightly soft. The face he wore when he wanted you to believe he was genuinely present. He was carrying nothing. Vanessa held the shopping bag, which, I could see, contained what appeared to be a bottle of wine and something wrapped in paper. "Sarah," Derek said, "I know this is unexpected. I'm sorry for not calling ahead. Can we come in?" "What do you want, Derek?" "I want to talk. Please. 5 minutes." He glanced down the hallway, then back at me, and something in his expression shifted towards something that might, in different circumstances, have looked like sincerity. I think we got off on the wrong foot with all of this. I want to make it right. I considered leaving them in the hallway. Then I thought, no, hear it all. Document everything. 5 minutes, I said, and stepped back. They came in. Vanessa set the bag on my counter, the wine and a loaf of artisanal bread from a bakery I recognized, and then stood beside it with her hands folded, performing a version of herself that was softer and more uncertain than anything I had previously witnessed. It was, professionally speaking, a decent performance. Derek sat at my kitchen table without being invited. I remained standing. "Sarah," he began, "I think there's been a misunderstanding. Whatever you've been told about my visit to Charleston, I want to explain that. I went there because I was worried about you. When I heard that you might be inheriting a significant amount of money, my first thought was about Ethan, about whether you had support, about whether someone might take advantage of you." I said nothing. I was, inside, cataloging every word. "I wasn't trying to interfere," he continued. "I was trying to look out for you, for both of you. And I think if we can just step back from the legal posturing," he smiled, the self-deprecating smile he deployed when he wanted to minimize something serious, "and remember that we're co-parents, that we have a son together, we can find a way through this that's good for everyone, especially Ethan." There it was. Especially Ethan, the card he always played last because he knew it landed. "Ethan is fine," I said. "He doesn't know anything about this." "And we want to keep it that way," Vanessa said, her first words since coming in, chosen carefully, the we doing a lot of work. "Derek has been talking about setting up an educational fund for Ethan's future. College, graduate school, whatever he needs. Something generous, something that reflects the fact that you and Derek are, at the end of the day, a family." I looked at Vanessa. I looked at Derek. The bread and wine sat on my counter between us. Was this a bribe? A settlement overture conducted without lawyers? An emotional manipulation disguised as a gesture of goodwill? Yes, all three. "I appreciate the thought," I said. "But I already have Ethan's future handled, and I already have legal representation, which means anything related to the estate or related legal matters needs to go through Marcus Webb." Derek's face changed. The softness didn't disappear all at once. It faded in sections, like a stage light dimming. "Sarah," he said quietly, "don't do this. Don't make this into a war. You have no idea what you're dealing with. This money, the inheritance, the trust structure you think you've built, there are vulnerabilities you haven't thought about. There are people who have been involved in Robert's estate for years, people with their own interests, who will not simply stand aside because you have a sympathetic attorney. Is that a threat? I asked. It's a reality, he said. Then I'll deal with the reality, I said. Through my attorney. I think you should go. Vanessa's mouth pressed into a thin line. Derek stood slowly, pushing back from the table. For just a moment, standing in my kitchen in the full daylight, he looked at me with something that was not anger, something colder, more calculating, the face behind the face. You're making a mistake, he said. Probably, I said. Goodbye, Derek. They left. I locked the door. I stood in my kitchen alone and waited for my hands to stop trembling. They took about 3 minutes. When they stopped, I picked up my phone and called Marcus. I told him everything, every word in order, as precisely as I could recall it. He listened. When I was done, he said, the in-person visit, the unscheduled approach, the reference to vulnerabilities, all of that goes in the record. That's pressure. Possibly witness tampering. We add it to the file. Okay, I said. Are you all right? I thought about it honestly. I was frightened. There was no use pretending otherwise. Derek's parting look had unsettled me in a way that the lawyers and the phone calls had not, because it had reminded me that this was personal, that he was not merely a legal adversary, but a man who had spent 8 years learning precisely which pressure points produced results. But the fear, I discovered, had a use. It sharpened something in me. It removed the last traces of ambivalence about what I was doing and why. I had been telling myself in the quieter moments that perhaps I was overreacting, that perhaps Derek's interest was, at some level, benign, that people acted strangely around large sums of money without necessarily being villains. The look on his face as he left my kitchen had settled that question permanently. Yes, I told Marcus. I'm all right. Let's file. The hearing was scheduled for a Thursday in February. In the weeks leading up to it, I experienced a kind of quiet that I had not expected and couldn't entirely explain. The fear didn't vanish, but it settled into something more manageable, the way a deep bruise becomes less acute and more structural over time. I went to work. I cooked dinner. I helped Ethan with his science project, a model of the solar system constructed from paint, wire, and an amount of styrofoam that seemed, in retrospect, excessive. I attended his basketball game on a Saturday morning and sat in the bleachers with the other parents and cheered when he made a free throw. And it was real. All of it was real, and I held on to it. Marcus had filed a civil complaint against Derek and Vanessa Mitchell alleging fraudulent interference with an inheritance and unlawful procurement of confidential estate information. Connor Briggs, the former paralegal, had provided his full written statement, signed and notarized. Gerald Wentworth had submitted a formal affidavit. The payment records, transfers from Derek and Vanessa's joint account to a personal account belonging to Connor Briggs totaling $14,000 over 4 months, had been subpoenaed and verified. Garrett and Simmons, Derek's firm, had filed a counter-motion arguing that the complaint was retaliatory and without merit, that the payments to Connor Briggs were for research consulting services, unrelated to the estate, and that Derek's visit to Wentworth's office had been undertaken in good faith as a concerned family member. Marcus had prepared a response to each of these arguments with the methodical precision of someone who found implausible explanations genuinely offensive. The morning of the hearing, I dressed carefully, not dramatically. A gray blazer, dark trousers, a silk blouse, and a shade of deep blue that my mother had once told me made me look like someone who knew what she was doing. I dropped Ethan at school, told him I had a work meeting, and drove downtown. The courtroom was smaller than I had imagined. Courtrooms always are. They carry such large weight in the imagination and then turn out to be just rooms, with fluorescent light and industrial carpet and the particular stillness of spaces where consequential things have been said so many times that the air has absorbed them all. Derek and Vanessa were already seated at the defendant's table when I came in. Derek was in a navy suit. Vanessa had chosen charcoal gray. Philip Garrett sat beside them, papers arranged with the confidence of a man who was certain he was about to demonstrate something. I sat beside Marcus. We did not look at each other. The judge, the Honorable Patricia Elms, was a woman in her early 60s with reading glasses on a beaded chain and an expression of sustained professional skepticism that I found immediately reassuring. She had, I knew from Marcus's research, presided over estate litigation for 11 years. She had seen every variety of what Marcus called inheritance-adjacent misconduct, and she was not impressed by any of them. Philip Garrett spoke first. He was smooth, organized, and fundamentally unconvincing, not because his delivery was poor, but because the arguments he was making required the judge to believe several things that the documentary record did not support. He described Derek's relationship with Robert Hale's estate as one of genuine concern for a vulnerable family member. He described the payments to Connor Briggs as legitimate consulting fees. He described Derek's visit to Gerald Wentworth's office as an act of familial due diligence. Judge Elms let him finish. She'd made 3 notes on her legal pad while he spoke. She didn't look at them when she turned to Marcus. Marcus presented the case in 22 minutes. He did not editorialize. He did not characterize Derek as villainous or Vanessa as calculating. He simply laid the sequence of events in chronological order: the initial estate attorney engagement, the access of confidential files, the payments, the visit to Charleston, the content and timing of Derek's communications with me, and let the record speak. Then he placed 3 documents in front of Judge Elms. The first was a timeline cross-referencing the bank transfers to Connor Briggs against the dates of Derek's communications with the estate office. The second was an email recovered from Connor Briggs's personal account in which Derek had explicitly asked Briggs to identify the primary beneficiary of Robert Hale's estate and to confirm the approximate transfer amount. The third was a text message from Vanessa to Derek, sent the evening of the day I had called the bank, reading, "Did they call you yet? We need to move." The courtroom was very quiet when Marcus sat down. Philip Garrett requested a recess. Judge Elms declined. She asked Derek's counsel if there was additional evidence to present. Garrett said there were several character witnesses available who could speak to Derek's. The judge raised one hand and the sentence ended. "Mr. Garrett," she said, "character witnesses do not address the documentary record. Do you have documentary evidence that contradicts these exhibits?" Garrett looked at his papers. He shuffled them once with the slightly too deliberate movement of a man buying time. "Your Honor, the defense maintains that the emails and text messages have been taken out of context." "What context," Judge Elms said, "would make 'we need to move' something other than what it appears to be?" Garrett did not have an answer. Derek leaned over and said something in a low voice to Garrett. I watched it from my side of the room, the whispered urgency, the slight shake of Garrett's head, the way Derek's jaw tightened. Vanessa sat very still beside him, her eyes fixed on a point approximately 2 feet above the judge's bench. Her hands folded on the table were white-knuckled. I looked at her. I felt no satisfaction. Not yet. What I felt was something closer to sorrow. Oddly. The waste of it. The spectacular, unnecessary waste. "I'm going to set a date for a full evidentiary hearing," Judge Elms said, "at which point I expect both parties to present their complete evidence. However, I am also referring this matter to the Ohio State Bar's Ethics Committee regarding the conduct of the former paralegal, and I am issuing a formal notice to the Cuyahoga County Prosecutor's Office regarding the potential criminal elements of this complaint, specifically the unlawful procurement of confidential information for financial gain." She looked up from her notes. "Mr. Mitchell," she said, "do you understand what I'm telling you?" Derek said yes in a voice I had never heard before. Flat, stripped of everything. I looked at my hands in my lap. I thought, this is what accountability sounds like. Small and ordinary and final. The full evidentiary hearing took place 6 weeks later. In the intervening time, 2 things happened that changed the landscape entirely. The first was that Connor Briggs, faced with potential criminal charges, filed an expanded statement detailing not only the payments he had received, but 3 specific phone conversations with Derek, in which Derek had asked him to determine whether the estate could be challenged on grounds of diminished capacity. Briggs had kept voice recordings of 2 of those calls. His attorney submitted them to the court. The second thing was that Vanessa hired her own attorney, separate from Philip Garrett, separate from Derek, and began the process of entering a cooperation agreement with the prosecutor's office. When Vanessa hired her own lawyer, I knew it was over. That meant she and Derek were no longer a unified front. That meant she was calculating her own exit. Philip Garrett withdrew from the case 2 days before the hearing. Derek arrived with a new attorney who looked like he was attending his second major case. Vanessa arrived with Lauren Cho and a demeanor that was, for the first time in my experience of her, genuinely quiet, not performed, the real thing. I wore the same gray blazer I'd worn to the first hearing. Marcus presented everything, the timeline, the emails, the recordings. Gerald Wentworth testified by video from his office in Charleston, a composed white-haired man who described, without apparent emotion, exactly what Derek had said during that visit, including the claim that he and I were still very close and that he was acting as my financial representative. We had never discussed anything of the kind. Judge Elms ruled in my favor on every point. Derek was ordered to pay civil damages totaling $3.4 million, covering my legal costs plus a punitive component the judge described as necessary given the deliberate, premeditated nature of the misconduct. He didn't have it. The Dublin house had been mortgaged to cover the early legal costs, and the rest had followed. The criminal charges came 3 months later. Derek was indicted on 2 counts: fraudulent interference with an inheritance and unlawful procurement of confidential information. He avoided trial through a plea, but not consequence. 12 months suspended, 3 years probation, mandatory restitution, and a permanent civil judgment. His employer, a corporate finance firm in Columbus, learned about the indictment and terminated him. In professional finance, a criminal record tied to estate fraud is not something you recover from. It follows you. I didn't seek that outcome. I didn't engineer it. It was simply what happens when someone's actions become public record. Vanessa's cooperation agreement reduced her exposure significantly. Probation and community service, no criminal record, but the marriage didn't survive. She filed for divorce from Derek 6 weeks after the judgment. The trust was fully established. The funds were secure. What Robert Hale had quietly, precisely left me was mine. I called Gerald Wentworth that evening. He said you reminded him of someone who hadn't given up, Wentworth told me. He admired that. He said it was the rarest thing. I thanked him. I hung up. I sat in the dark kitchen of my 2-bedroom apartment and for the first time in 4 months let myself cry. Not from fear or exhaustion, but from the particular grief of being seen by someone you never got to know. I did not buy a mansion. The transformation was real, but quieter than that, more interior. 3 months after the judgment, I bought a 4-bedroom colonial in Bexley, a neighborhood on the east side of Columbus, with a backyard large enough for a dog and a screened-in porch that faced west. The evenings there were warm and golden in a way I found, after that long and brutal winter, genuinely restorative. Ethan chose his room in 45 seconds and filled the shelves with model spacecraft and dog-eared library books. It looked like him within a day. That is the truest measure of a home. We got a rescue mutt named Biscuit, brown and white, sturdy, anxious-eyed, who slept at the foot of Ethan's bed and barked at squirrels with a commitment I found admirable. The house felt different with a dog in it, warmer, less provisional. I left Hartwell and Associates in the spring with a proper notice and a genuine farewell. Then I spent the better part of a year building the Robert James Hale Foundation for Educational Access, scholarships and college preparation programs for under-resourced communities across Ohio. It was, I believe, what Robert would have wanted, a quiet man investing in structure before anything else. And Derek? The Dublin house sold in a short sale. The civil damages, legal fees, and months of litigation had hollowed out everything he and Vanessa had built together. He found work eventually. Bookkeeping for a small construction company in Westerville. Not vindication, consequence, which is a different thing, and I think a better one. Vanessa moved to Cincinnati after the divorce. I didn't follow her story beyond that. I had no wish to. When Ethan was 15, I told him everything. He listened carefully, asked sharp questions, and at the end said, "So you just did everything right?" "I tried to," I said. "It's scarier than you think, and slower." He nodded slowly. Then, "Good." What the money gave back to me most of all was time. Time to be present. Time to build something that mattered. Time, on that west-facing porch in the evenings, to watch the light change and feel something I hadn't felt in years. Something uncomplicated. This is what it was for. Not the money. This. What would you have done? Would you have taken the settlement and walked away? Leave your answer below. I genuinely want to know. Thank you for listening all the way to the end.